The Contracts-Torts question from February of 1998 is mostly a contracts question. Here's a hypothetical that requires us to use all of our techniques to spot the issues and organize them carefully. Have a look with me at the call of the question. 1. What, if any, rights and remedies does carrier have against 1. Maker? Discuss. 2. Transport? Discuss. Well, we've got one plaintiff and two defendants. Carrier is going to have one or more theories of liability against each one of these defendants, and carrier also, presumably, will have one or more prayers for relief. These are going to involve damages, restitution, or some form of equitable relief. Based on the call of the question, it's a little hard for us to guess what subject is being tested. Certainly we can narrow it down to torts and contracts and property. The fact that we've got a party named Maker suggests that we are dealing with contracts, but it's not very important. What is important is that we can organize our basic answer based on the call of the question. The plaintiff is going to have a theory of liability. The defendant likely will have a defense to the theory of liability. The plaintiff will seek remedies. Again, the defendant may seek to impose defenses to remedies. That's the basic structure. Now let's go find out who these parties are and what this dispute is all about. In paragraph 1, we find out about the agreement between carrier and maker. So our first defendant also is a party to a contract with carrier. So instantly we begin to think about our basic approach to contracts. Formation, defenses to formation. Breach, defenses to breach. Remedies, defenses to remedies. And as we look at the terms of this agreement, it's quite interesting. This is a common law agreement, but we've got merchants involved in a contract for services, a requirements contract for services. So ultimately, the common law is going to govern any disputes that arise between these two parties. That's a distinction that ultimately doesn't make a huge degree of difference for us. But still, we're going to have to track what goes on quite carefully. We also see in paragraph 1 that carrier has the right to terminate this agreement if a legislative contingency occurs, which would make the contract unprofitable for carrier. In paragraph 2, we find out about the contract itself, by which I mean the document. Carrier drafts a contract that has these terms, signs it, and sends it off to maker. But maker never signs it. So, do we have an agreement or not? Well, based on the conduct of the parties, it's quite apparent that we do, because the parties begin to fulfill the terms of the agreement according to its terms. And so carrier is carrying packages, invoicing maker, maker is paying those invoices. For 6 months, all of this goes fine. So, do we have an agreement? Answer, yes. Is that agreement the one spelled out in the written contract? Again, yes, even though maker never signed it. Why? Because maker performed, and also because we learn about carrier's detrimental reliance. They pass up a couple of lucrative jobs because their carrying capacity is consumed by the contract with maker. Then, in paragraph 3, the last paragraph, in a comparatively short and difficult fact pattern, we have maker having second thoughts about the cost of carrier's services. So they send a letter to Transco, that's our second defendant, and maker describes their needs, and also maker describes the agreement with carrier. So although we don't technically have a writing signed by the party to be charged, this conduct of maker further supports carrier's argument that, in fact, they had a binding contract and that both of them knew what the terms of that contract were. Next, transport comes back and answers a competitive price for the same service. Now, thinking ahead, the second call of the question has carrier suing transport. Well, transport was never a party to any agreement with carrier. So the only possible theory of liability arises out of torts. And typically it would be the business tort of interference with contract or possibly interference with prospective advantage. But it would be better to label this in terms of interference of contract. But think for a moment. This new company, Transport, didn't go out of its way to try to get this business. This looks to me more like legitimate business competition than it does intentional interference with contract. As it turns out, the facts are presented in such a way that one reasonably could reach either of those two conclusions. So, in the third paragraph, we have the exchange of communications, and finally, the result is that maker breaches the agreement with carrier, agrees instead to deal with Transport, and it fails to pay maker's last invoice. So then we get the call of the question again. This is a question that really is quite complicated and difficult, especially to complete within time constraints. Turn the page and have a look at the outline of issues that I offer. You'll see that I have done a fairly meticulous job in organizing my answer to this question. This is one of those short fact patterns that really requires us to find a home for all of the details. So have a look at the way I've organized the analysis. First, I talk about formation, and it seems evident that this is a valid requirements contract. But what are makers' defenses to formation? They can argue that the statute of frauds. They can argue that there was never really an agreement because the so-called contract isn't specific about either the quantity or the price. And the defendant can argue that really this is an illusory promise. It isn't even really a legitimate contract at all. Now, although those arguments all are colorable, they're plausible on their face. A more careful analysis of the facts of the case clearly indicates that there is a valid contract. Maker knew it, and maker ought to be held to its terms. We turn to breach. The breach is simple. Maker repudiated the agreement. That means that carrier has the right to sue now, sue later, or seek further assurances. Finally, we consider briefly defenses to breach. It doesn't look as if there are any, other than maker relying on the contract being invalid. And since we've already found that there is a valid contract, maker's going to be on the hook. So then we turn to remedies, and we look at expectation, consequential, and punitive damages. Clearly, there are no punitive damages available for this sort of breach of contract. However, the other damages are going to be compensable to the extent they can be proven up. This is a plaintiff who has not been paid for a specific invoice. Clearly, damages are the preferred remedy. If there's a problem here, the plaintiff could fall back on a restitutionary theory of recovery. Finally, we consider equity, briefly, specific performance in this context, and we find specific performance is not going to be available. Then we turn to the second lawsuit, which is the simpler lawsuit. We'll spend a lot less time on this one, but we consider carrier versus transport. We discuss tortious interference, and we find a home for all of the facts. You'll see in my outline, I use the facts as an organizing principle within this theory. And the reason is the elements of the theory don't give us as good a structure for our answer. Then the defense that transport will offer is the business privilege. And here, as often is the case, I'm pretty sympathetic with the defense. I don't see transport being a bad guy in this pattern. Transport was contacted by maker, transport gave its bid, and the result, transport made a deal. Now, one clearly could argue that transport should be liable. And, in fact, even I grant that there is a reasonable chance they could be liable. And if they were, they'd be subject to compensatory and punitive damages. You'll also see I touch briefly on replevin, although in this matter I don't think it available. So that wraps up how to organize this hard question. Now have a look at my model answer, and let me give you some insights about how to write a good answer. Again, this is a complicated problem and a reasonably short fact pattern. So we've got to find home for all of the details under time constraints. So look at the very first paragraph. As usual, I lead with the facts. I identify the parties, the theory, and the fact that this is a common law agreement. Then formation takes me about 2 lines to deal with. This is not a formation problem. This is a breach and remedies problem. So we turn to defenses to formation, the statute of frauds, vagueness, etc. Notice these are arguments that go to the validity of the agreement, not so much to its terms. Finally, it's evident that this is a valid requirements contract. And even though it isn't a UCC contract, these are merchants, and they are dealing on a commercial basis with one another. Now, I am not applying UCC principles to this transaction, not at all. But as I interpret the relationship between the parties, given the business context in which this dispute arises, it seems to me reasonable to grant these two merchants a little bit of flexibility with regard to quantity and price, given the other terms of the agreement. The repudiation by maker is fairly straightforward, but you'll see I spend 3 short paragraphs establishing the breach, establishing the legal options that the plaintiff has in light of the repudiation, and then reaching the conclusion that it is a breach that can't be defended against. So then we turn to remedies, and here, with regard to damages, you'll see that although we don't have any real numbers to work with, I go into a fair amount of depth about how we would calculate these remedies, so that the expectation damages would be placed on the potential lost profits over the course of the deal. And even though maker already has breached, maker could conceivably be on the hook for the duration of the agreement, subject to carrier's duty to mitigate. Then, turning to consequential damages, these damages would be the lost profits from the 2 big jobs that carrier turned down as a result of relying on the existence of the deal with maker. Here, again, I find a home for that little detail about carrier having the right to terminate the agreement. The contingency that would allow that didn't occur. Therefore, we've got a binding contract on both parties. I turn to restitution, just long enough to explain that this remedy also would be available to the plaintiff should the plaintiff not choose to pursue a contract theory. Similarly, I touch on specific performance just for a couple of sentences. Clearly, that's not at issue here. Damages is. Then I conclude carrier gets damages for everything carrier can prove up. Turning to carrier versus transport, here I focus on the tortious interference with contract theory of liability, and you'll see that I use the elements of interference as the structure of my answer, and I tie in the facts as well. Realize that almost every time we've got a lawsuit where the plaintiff is complaining about the abuse or breach of a contract, then the defense almost certainly will be the business privilege. And in a free market economy, all of us have a right to compete against one another. The question is whether or not the conduct of transport crossed that line. Now, one could readily interpret these same facts to reach the opposite conclusions. I look at it and I conclude that assuming there is such a tortious interference, that the plaintiff will be limited to damages. It seems to me that this is a very close call. So taken as a whole, this is a common law problem that comes very close to being like a UCC fact pattern. But the approach remains the same. We focus on formation, defenses to formation, breach, defenses to breach, not really present here, then remedies and defenses to remedies. In this case, I find principally in favor of the plaintiff.